to you guys. We are beginning today the last day of our Ethereum Unlocked Summit. And the first speaker is Maria.
Hello. This is on. Yeah. Hello, everyone. It's amazing to be here. Thank you so much. This is not the first time I'm here at the block. First time was about 2 years ago when I was collaborating with one of the projects that got incubated here called Tokenization. My name is Maria. I am a lawyer. I am currently working at a law firm called MM Law, and I am in charge of the tokenization department where I refer to blockchain, not only tokenization. And the talk I'm here to do today has to do with the legal aspects to bear in mind whenever having a Web3 project. Where to start, questions to ask, and to understand specifically or especially the legal framework here in Europe. The complicated part when it comes to law and blockchain is basically where to start. Where does it apply? Because it's pretty much global thing, isn't it? So the topic today has a lot to do not only with tokenization as it said, but the regulation that's related to it and even the services that we're going to provide with blockchain, right? So the thing about law and Web3 is that it's the third leg that people usually forget about. When we're talking about Web3 projects, we're going to go to our three main legs that usually we develop, so we know that everything is balanced, which is the legal, the financial, and the tech. There's people that fall in love with the tech part, everything that can be built, but they forget whether the business model works or the legal part is in sync. There's people that, on the other hand, fall in love with the financial part, the business model, the money that you can make, how you can get to the moon. But if you don't have the technical team that can actually pull it through, especially when it comes to safety, or if you don't have the legal part, think like, well, structure, then you can have legal problems that you like to avoid way worse than just fines. And then when you just have the legal leg, we're missing a lot of the force and traction that you need for a project to work, right? So it's the three legs that we're bearing in mind for things to pull through. And especially the legal leg and the financial leg that work together in sync, because whenever you're working, for example, with tokenomics, and you have to do something adapted to fit any kind of regulation, you're going to directly attack or affect the business model. This is going to depend on who you can offer it, how much, and whether you can really need or not. Here in Europe, when it comes to DLT, or blockchain, it depends on the activity or the kind of token that you're going to issue, whether it falls within one of these regulations. MiCA is a very important piece of regulation in Europe, in an international level as well, because it goes through some of the main activities that are related to blockchain, those that have to do with stable coins or asset reference tokens and e-money tokens. We can put them together as stable coins, and as well utility tokens, which is other than discount tokens. But also the service providers that have to do with this three. So MiCA is going to apply whenever we know that we can be considered a crypto asset service provider, they're going to call it CAS. So if you're a CAS, you're going to have to ask for a license, and it's everything that has to do with exchanges from crypto to fiat, fiat to crypto, to placing orders, to any kind of services, maybe most of the time that have to do to any of the these tokens, right? Then we already know that we might have to apply for a CAS license. Why is this regulation also important? It's also important because there was, up to date there still is, let's call it forum shopping or jurisdiction in Europe when it comes to DLT, because each country would rather have a pretty well thought through legal framework for DLTs or not, or something in the middle. Just to say, for example, Germany is well developed in the matter, Spain as well, France as well. Then you have Portugal that's starting little by little to have their own regulations, like the BAS, that's a virtualized service provider license that you would require. And then you would have other countries in Europe that would be easier or faster to get a license, like Estonia and Lithuania. The thing about the creation of MiCA is that now every country in Europe is going to have to adapt to it. Their NCAs or the competent authorities, the national competent authorities, are going to have to apply this kind of regime, and the same conditions are going to apply to get your license. So what's going to happen is that mostly one of the main differences that are going to come from one country to another to choose the jurisdiction for a project is going to come from taxes. Because when we're talking about the European Union and this kind of regulations, they do not interfere directly with the sovereignty that each country has in their taxes. So that's going to be one of the main and core subjects that's going to make you decide over one jurisdiction or the other for a project. And the rest of the legal framework that the country itself has related to DLT and other kind of activities, like for example, that related to financial instruments or security tokens. Let me explain that again. So we have a country like Germany. Germany is very well developed with DLT regulation, and then we have Portugal, which is midway compared to other countries in Europe that have no regulation whatsoever of DLT. If I have a project that itself doesn't have to do with, let's say, utility token or stable coins, but with security tokens, in Portugal there's not a direct regulation on the matter, nor in the European level. So what we have to do is just follow the traditional framework that they have on financial instruments in Portugal. When in Germany, they already have an Electronic Securities Act, and they even have one specific regulation that has to do with tokenization of units in usage with a specific kind of fund. So that way, even though it might seem that it becomes more bureaucratic to an extent, it gives more certain legal, it gives more legal certainty to the project itself. But let me go a little bit back because it can be a lot of information in little time. Whenever we know that in Europe we're going to start working or have a project that has to do with stable coins, either in ART or EFT, or that we're talking about utility tokens, we know the MiCA itself is going to apply. MiCA was approved this year and it's going to start enforceability by mid and next year. So your project is going to have to apply for whatever jurisdiction you're in for this license that can later on be passported, so you can also work and also target other markets in the rest of Europe, which is important. But what happens with the fact of working, for example, with financial instruments or services that are related to financial instruments? There is not such thing like a MiCA for security tokens, or at least yet. On that sense, what would happen in this case is you have a project that has to do with a service related to financial instruments or the issuance of a token that can be considered a financial instrument. There is no MiCA, so we go to traditional markets regulation, which is MiFID II. There's something very interesting that not a lot of people know, that this year, the enforceability of a new regulation related to financial instruments or tokenization of these financial instruments just started, which is called the DLT pilot regime. Now, it's not a directive, it's not a regulation, it's sandbox, a European sandbox. And why is it interesting? Because it would enable those projects that apply to it to gain exemptions from the usual regulations that you would have to comply with whenever working with financial instruments or the services related to that, which is MiFID II, MiFIR, and the CSDR. We're talking about the Markets in Financial Instruments Directive, the Markets in Financial Instruments Regulation, and the Central Securities Depositories Regulation. Which means that in this case, from now on, especially now in Portugal, they already implemented it, there's a possibility for projects that are related to security tokens, for example, to apply to this regime in the last 6 years, and to be exempted for some of these regulations that in either case will make the work or the application, the infrastructure of the work a lot more burdensome. And some of the exceptions have to do, for example, on being able to reach certain kind of retail investors without requiring a broker-dealer license, or the kind of licenses that have to do with depositories and the regulation that has to do with central securities depository. That's interesting because it makes it easier for the project not only to be set up and to operate. On this case, there are three kinds of licenses that you can apply through the DLT pilot regime, that is to be a multilateral trading facility, or a settlement system, or a combination of both at the same time. So in this case, what we can see in the European framework so far makes you ask your team, okay, what kind of service or product am I actually offering, to understand if there's already a settled down regulation for me to follow. And the fact that there is not specific DLT regulation that I would have to follow does not mean, I'm not saying I can just do it, it means that you're not getting in a lot of trouble if you don't check this first. There's a saying in Spanish, I'm originally from Argentina, that's, I'm going to speak Spanish, is, aunque la mona se vista de seda, mona se queda, which means if you have a monkey that's wearing a silk dress, it's still a monkey. That's the thing, in the sense that even if there's not a regulation for whatever service or product you're offering, go to the traditional one and try to adapt to it through that path, until a regulation that specifically for it might happen, because you might still have problems. Another example on this Spanish phrase is the amount of issuing a token that can be considered a financial instrument through the eyes of what is a financial instrument in Europe here, which is different to the consideration of a financial instrument in the US, here you don't apply the how test as an example, then you will most likely still be considered liable for license or registration and the other kind of permits that you might need for that financial instrument, even if you sugarcoat it with blockchain, even if that sounds kind of harsh. The interesting part is that the DLT pilot regime, which I just mentioned, is not yet a directive or a regulation, but is the sandbox that could be the pre-step for what we're seeing as MiFID 3. In this sense, it's also important to know that after we understand what's the service, and what's the activity, what's the product that we're going to work with, and whether there's a DLT path on how to be compliant, or the traditional one for us to at least bear in mind, is to know that if we are working with stable coins or the service related to stable coins, okay, we have MiCA. If we're working with utility tokens, which is a token that I'm pretty sure you guys already know, is the one that gives you the right to a good or service directly, then you're going to go to MiCA as well. And if we're already talking about the financial service or the service related to financial instruments or a token that's a security token, then we would have to go to MiFID, considering as well in European level the DLT pilot regime, and depending on the jurisdiction that we want to work in, if they have a regulation rather. Again, the example that I gave before, Germany has one, you would have to follow it. And Portugal doesn't, so it would have to be the traditional way. When it comes as well to this chart that I'm trying to show over here is that when it comes to law, one of the answers that clients get and that they hate the most of our lawyers is that when they make a question, we say it depends. Because many times it depends. But in this case, one of the things that I can say is that exemptions can become your best friend. That means trying to go through the regulation that you see that applies to your project. And when you identify the activity that you're doing or the product that you're, or the token that you're issuing, try to find the exemption within it to make your job or your project easier on the sense that if we do realize that our project, for example, has to do with something like the issuance of a utility token, we're going to go like, okay, utility token, that was MiCA, we're going to have to apply the regulation of MiCA management. But in that sense, you would have to comply as well with certain requirements for utility token to be compliant with, which would be, for example, a white paper, the safeguard of funds, some marketing consideration that could still limit part of the project that you're trying to do. So if you realize that your product, it's not an ART, it's issuing a token that's not an ART, nor e-money token, and could fall with an utility token without being considered a financial instrument, through the consideration of financial instruments here, which is different to the US, then you say, how do I make my utility token fall within the exemptions of MiCA on the requirements that you would have, for example, white papers or the safeguard funds? Why do I say this? Because white paper, we all know how to make them, or we all know how important they are for a project, but in this case, you would have to notify the National Conflict Authority. You would limit a little bit your actions on the marketing that you would do it, and the safeguarded funds would still block you the access to the funds that you would be getting until the moment of, let's call the burning of the token, which could be a little bit of a pain in the neck, not to say words, because I think this is being recorded and I shouldn't say. And so we understand it's not a financial instrument. We took out characteristics that can make it look like a financial instrument. It's not a stable coin because that would also make it more troublesome because you would have to be very compliant to very similar regulations like the license for e-money that exists in the rest of the European Union. What are some of those exemptions? Exemptions like, for example, having a utility token that represents the access to a good or service that already exists. It's a good or service that's already operating right now. Or it's considered a reward as another exemption to validation or, for example, any kind of maintenance for the protocol. Or to a utility token that gives you access to a good or service in a case of a closed network of people that have an agreement with the issuer, is another example. On that extent, bearing in mind the different kind of exemptions that you have on regulation on your best friend, so you would follow through the path that you're supposed to with regulation, but you still do it in a way that be beneficial for you. On this case, the thing that's still not fully certain in Europe on what falls within or not is that we know that in MiCA, we don't have the regulation of NFTs or DeFi or DAOs. The thing to be careful about that is that when we're talking about DeFi and we're talking about DAOs, we're talking about a concept of decentralization that's still not fully clear, I think, pretty much anywhere. We know that decentralization is not black or white, or we're talking about a gradient that can be sufficient. So telling yourself or your project that you don't fall within MiCA or even MiCA because you're decentralized makes you have to take a further step to understand to what extent you're really decentralized enough not to get involved with complicated authorities. And when it comes to NFTs, the concept itself as well of unique and non-fungible can be challenged depending on whether you are issuing too many of them, you're patronizing too much, even one NFT into another account, and the fact that even though you're having an NFT, that NFT is where itself, it's still an NFT in the sense that if that NFT is still the tokenization of financial instrument, you're still going to have to go through either need to apply to the DLT pilot regime. This is a little bit of an overview of what I wanted to show, but it's a good way to think about an analysis from the top and from the bottom. From the top, you think about in a European level what would apply to you, whether MiCA, whether MiFID, whether pilot regime, whether, for example, the e-money directive. And then from the bottom, you think about, okay, what's my project? What's the activity? What's the service? And what's the product? Which one am I tokenizing or not? And see from a domestic law where it applies to a DLT regulation or actually one that's on a traditional level, and try to make them connect. So you get to understand for your project, where do I want to operate? What market is it? Is it already set up? Is investment coming in? From where? And if I'm trying to get it, who and how do I want to operate? Is it in a public way or is it in a private way? In this sense, it's also interesting and important to think about, I'm having a token right now, how the token is going to evolve, because the taxonomy or the classification of my token might as well change and evolve into one token or the other, which would make our requirements change. On this sense, what I wanted to explain, I hope it's, I didn't want you guys to go back to bed because we know a lot of it will be boring, that the fact that a specific kind of activity or token is not fully regulated right now does not exempt us from actually being compliant. We still have to check out the traditional regulation that's in it. And there's a lot of interesting projects or bills happening right now in this time. As an example, I was on Monday at a crypto regulatory conference where the vice chair of the CMBM was present, and one of the things that she mentioned beyond the importance of the DLT pilot regime in relation to the financial instruments and tokenization is that DLT pilot regime will not only become pre-step to MiFID 3, but the fact that the CMBM itself, that will be the 14th version of the SEC, is working on its own sandbox to work with projects and help the projects for free to set up compliantly portals to what we're trying to do. I know I had a lot of information in very little time. I hope it was helpful for you guys. I'm currently working at a law firm, which is really close to here. So if there are any questions we have, the rest of the team over there, and we'd be more than happy to listen. And yeah, and I forgot, I could have used this. So sad. Okay, I made a little party. Thank you guys. Thank you. Articles, the concept of MiFID of financial instruments is different than the one in the Howard test, and I classify over this PPT if you want, because it shows how it's different and the actual aspects that you need to bear in mind. Here you hear mostly about transferable securities, the word of transferability, most important, and then on the other one, negotiability. That's what makes the difference with the Howard test and the four steps that they have. And there's a taxonomy as well. If you're talking about shares, you're talking about bonds, or any other kind of securities with such characteristics. This is important because most people think that the Howard test is how you know what's a financial instrument. If you want to target European consumers or clients, or even from Europe, then you should care about this one. And you guys think it's also But I'm just going to give you that one. And that's how you can put it.
Thank you for the presentation. Maybe one just quick question from my side. More general one, based on your experience and on your clients. Are they afraid of MiCA? Do some of them are thinking about like moving to more crypto-friendly places like Dubai, Singapore, for instance? Want to understand basically what is the feeling of the industry about this regulatory coming in Europe?
So it's funny because there are different stances about MiCA. My stance on the matter is that I don't think regulation is necessarily a bad thing, on the sense that regulation that does not block innovation is what we're looking for, and depending on the country and the jurisdiction is how you can combine with that. Even though MiCA is not perfect, and I think that it can become too burdensome for a core project to comply with many of the things they're asking, like safeguard on money and funds, for example, I do believe that having imperfect regulation can be better than having more regulation. So every stakeholder of the project can feel safe. From the consumers, whatever, so they know that if there's a problem, they know who to actually go to, and if they don't reply, who would take action on them. The investors, so they know where the money is going, how it's being treated. And the project itself, if they ever have a problem with consumers or investors. The thing about choosing other jurisdictions, it would depend on what's the stage of the project would be. What happens a lot is that projects choose a friendlier and more flexible jurisdiction for the setup and the fundraising on PPR and Cayman Island and Dubai. And whenever they're fully set and a little bit more robust on money, they comply in Europe so they can feel more comfortable, especially making or being very careful with who are they targeting and how. So if you want to have a well-set project in Europe that targets European, then it would be better to have it here, even though when it comes to taxes, it doesn't matter. But you're not going to have the doors so open when it comes to dealing with taxes, for example, because they're going to know what's in Dubai. Yeah. That would be a way of looking at it. But that's my personal view on that regulation that does not block innovation is always wrong.
Yeah, thank you very much.
Thank you very much.
Now, next one question. No, it's okay.
I have millions of questions. I was just, this is a little bit cheeky because I'm basically asking for legal advice, but I guess that's why we're here. I'm involved in a project that's looking to tokenize carbon credits, the regulatory ones. And everything that you just said is extremely interesting. What are regulatory credits and developments and things like that? Are they financial instruments? If you sell them, are they?
That's a very broad question where we don't have the full disclosure of what are the characteristics of the token. It would be, when it comes to carbon credits, there is no European regulation of DOT carbon credits. I think it would have to do with how are you representing those carbon credits and who has the ownership of it. Let me give you an example. When it comes to real estate and Web3 and tokenization of real estate, there is a common misconception on that we're directly tokenizing property. There are only very few countries in the world that directly do that. One of them is Liechtenstein, because they changed the full regulatory framework, even changing the stable code, where you can directly tokenize them. And then you have Georgia that tokenizes the public registry. What you do, just one second, I think it's gonna make sense. To be able, the rest of the countries which have a special instinct to tokenize private property, real estate, is to tokenize the vehicle that has the ownership of the real estate, so you tokenize the shares of the entity that has it, for example, or the fund that has it. In the case of the carbon credits, I don't know if you're having an entity that has the ownership of them, or them directly.
We're kind of trying to figure it out.
Okay.
But we were talking about Dubai, and of course, then that's like, what was